Good morning, everybody. I'm Ed Avis. I'm the publisher of El Restaurante magazine, and I want to welcome you to our webinar today titled What Restaurant Owners Need to Know About Immigrant Workers in 2025. Before I introduce our honored speakers, I want to welcome you and tell you that we welcome questions. This is your chance to ask the professionals any questions you have on these issues that they'll be talking about. And you can see at the bottom of your screen, there's a Q&A tab. So please direct your questions in that tab if you have any, and then we will answer them either during the presentation or afterwards. Also, want to note that this event is being recorded, so you can watch it later on the El Restaurante website, or you can share it with other people in your restaurant. And with that, let me very quickly introduce our speakers. We have with us today Mary Pivec, Catherine Cat Walker, and Becki Young, who are all attorneys with Grossman Young and Hammond. This law firm handles immigration issues, and they have, for us, done webinars in the past that were very well received. So we are delighted to have them with us here today, and we look forward to what they're going to teach us. And with that, I'm going to turn it over to you, Becki.
All
Thank
right. Thank you, Ed. So great to be here. And this is a topic that's top of mind for many people around the country. I know. I manage the employment-based immigration practice at Grossman Young, and Mary Pivec is of counsel to our firm. She is an expert in employer compliance, which is obviously a hot topic right now. And Kat Walker joins us from Miami. Kat does work with humanitarian immigration options, including asylum, TPS, and DACA. So just to roadmap our presentation today, Mary is going to speak for about 20 minutes regarding employer compliance and what employers in the restaurant industry in particular need to be thinking about at this moment. And then I'm going to speak very briefly about sponsorship of workers in the hospitality industry. This is a topic that we definitely address a lot during normal times, but a lot is going on in the world right now, and so I suspect that many of you will be very interested in what Kat has to say, and she'll wrap up with humanitarian options and possibilities for individuals who are here in humanitarian status. So with that, I will turn it over to Mary to talk about employer compliance.
Thank you, Becki. Well, good morning, everyone. Can you advance the slide? Let me introduce you to the world of who's compliant or who is enforcing the worksite compliance requirements of the Immigration Nationality Act. I'm sure you actually do not need any introduction to U.S. Customs and Border Protection, but that's not the agency. It's actually ICE. Immigration and Customs Enforcement is the agency that is charged.
Oh, it looks like Mary is frozen. We'll give her a minute to get unfrozen.
Becki, do you maybe want to jump onto your part of the
Yeah, why don't
presentation
we
while
go
we
ahead
wait for Mary?
and skip ahead, Christina, if you can skip ahead to the slides on, oh, yeah, Mary, okay, if Mary dials back in, we can get there.
Oh, here's Mary again.
Is Mary back again? Okay, good. Sorry for the technical difficulties, folks.
All right, everybody. Well, I was introducing you to the world of ICE. ICE actually has a subdivision called Homeland Security Investigations. These are special agents who have been through the FBI Academy. They carry guns. They are law enforcement officers in every sense of the word. They are the ones who will be interfacing with your personnel, with your restaurant in the event of an enforcement action. There are three kinds, actually. They are involved in executing I-9 verification audits. They also serve arrest warrants. And lastly, they can be involved in executing workplace raids. Typically, they are not acting, this agency doesn't act alone. They act in concert with other federal and local law enforcement agencies who have been deputized to assist them in immigration enforcement. Can we go to the next slide? The most important thing I can tell you today is to be prepared should they pay a visit to your facility. And how do you do that? You need an action plan. Before they come out to a work site, they've cased the place. They know what it looks like. They know where the entrances and exits are. They know if there is a person in the front of the restaurant to receive or not receive them. Actually, that's an ideal situation for what I'm going to tell you in terms of preparation. But there are many restaurants who do not have a receptionist in the front. The process is to go directly up to the service counter and to order. There may or may not be service personnel on the floor delivering orders to clients. But you need to know how the layout of your restaurant will be perceived by ICE agents and what is the best way to prepare that facility for their coming. If you have back of the house that is closed off to the general public, but there is a door there, I would advise you to post that, private, no entry. That will ensure you that they will need a warrant in order to trespass that entrance, a valid warrant signed by a judge. We'll talk about that in a few moments. Otherwise, they can't go back there, and you should not consent to their going back there. There have been reports of ICE agents coming in or coming up to food trucks or coming up to open air food vendors, and they don't need a warrant in those cases because it's an entirely public place open to the general public and also open to ICE officers. But if you have a closed door restaurant and you have a reception desk at the front of your restaurant, the person who is manning or womaning that location should be prepared to deal with an ICE official or multiple ICE officials should they present themselves at the entrance. What's the best preparation to do? If you have already retained counsel to advise you in the event of an interaction with ICE, make sure that the person at the front desk has the name of that counsel and their phone number in case she is the one or he is the one to make the call to notify counsel that ICE is on the scene. The person at the front desk should also know who is in charge in the restaurant on that day. Who is the person who is going to be authorized to interface with the agents? Not everybody in the restaurant should do that. There should be a designated person who is calm, cool, collected, and is able to manage the situation, even though it may become hectic at times. Now, when agents come to serve a notice of inspection, there's generally 2 or 3 of them. There may be more. We have seen evidence of coming in more than 2 groups of 2 now, but the third person is not immediately visible when the 2 present. The third or fourth may be at the rear exits of your restaurant, waiting to see whether or not any individuals will run when they become aware that ICE is on the scene. Be aware of that. And hopefully, whoever is in charge in the restaurant will counsel employees not to run, because that's probably the worst thing they can do. It will be used as evidence that they are conscious guilt of undocumented status. Now, could we go on to the next slide? we'll talk about the I-9 compliance audits. The first thing that the person at the desk should do is to secure the identification information from the agents. If they have their cell phone with them, take a photo of their cards. Or if they will give you a card, and sometimes they won't, take the card from them. More and more, ICE has been serving notices of inspection by certified mail. They no longer have to do it in person. They actually like the control that it gives them if they serve it by certified mail. They don't spend any money in coming to the site. And if they have no intention of arresting anybody during that visit, then the most effective way is to serve notice on the registered agent for the restaurant that a 9/9 inspection is being requested. If they do show up to serve the notice, your feeler should go up, because generally that means they're there to take a look around and see if they observe persons who, from their mere appearance, appear to be undocumented. They have the right to go up and to try to question individuals about their name, their status. I'm going to leave it to Kat to talk to you about what those individuals can or cannot do. But the employer himself or herself should not be advising employees in that instance to remain quiet, because that could be interpreted to be obstruction on the part of the employer, something you do not want to be charged with by any means. The visit should be relatively short. They're there to serve the letter. They may ask the employer whether they will produce the I-9s immediately, and that's probably the worst thing that can be done. You have a minimum of 3 business days in order to produce the documents. Generally speaking, they can be produced electronically. They don't have to be produced in hard copy. And it's probably best not to have, there's really no need to go into a nice office or to the SAC office in order to deliver the I-9s. It is always best to have prepared that inventory of I-9s before they arrive. And I would hope that everybody by now has, if they have not already, checked their I-9 inventory to ensure that everyone who is currently employed has a properly completed I-9, and that those documents are ready for production in the event of an ICE audit. I will mention that the ICE audits, which are, can we go to the next slide? Well, ICE audits these days typically are accompanied by, or notice of inspection letters are accompanied by an administrative subpoena. And the administrative subpoena requests information which is in addition to the I-9 documents themselves. They will want the employer to produce 2 separate rosters, a roster of active employees with their dates of hire and social security numbers, sometimes with their job titles, and a separate roster of employees who have been terminated, who are within the terminated, but whose I-9s are within the retention period. If they were employed for less than 3 years, then it would be anybody who has been employed for less than 3 years, there should be an I-9 on file for them. If they were employed for more than 3 years, then you need to keep that I-9 for 1 year following the date of their termination. These subpoenas are also requesting information. If you're using an electronic I-9 vendor, they're requesting information to be produced with respect to the compliance of that vendor's software and systems with the DHS regulations. We are discovering more and more that systems commonly used, many systems commonly used, which integrate human resource software with I-9 software, are not necessarily compliant. The biggest issue we are finding is that some of those systems cannot produce an audit trail that documents who entered information on the I-9, the electronic I-9 form, when they did it. And That audit trail is critical to ensuring that the employee himself completed Section 1 of the I-9 form and signed it, and that the employer representative, after having inspected the original documents in the presence of the employee, completed Section 2 of the I-9 and signed the attestation. You should be aware that some of these electronic I-9 programs also provide for electronic signatures that do not comply with the DHS regulation. The DHS regulation requires that before the employee or the employer representative sign the attestation electronically, they must also check off an attestation that they have read the attestation in full and that the information that they're providing is true and correct. Evidence of that check has to be part of the audit trail, or the I-9 itself will be deemed to be non-compliant, as if you had never done an I-9 at all. I don't want to spend too much time on this, but if you are not sure whether your electronic I-9 vendor is compliant, check with counsel. Now, there are two types of warrants that ICE agents may be carrying with them. A judicial warrant is a warrant that is signed by either a federal magistrate or a federal judge. And the judicial warrant specifies the version of the law or the portion of the US Code which authorizes the search. It will designate that they're either searching for persons or evidence or both of violations of immigration laws. It will designate when the search can be conducted and the areas of the business that can be searched. The warrant should be read carefully by whoever is in charge at the site, and when the warrant is being executed, that is, the agents are going to search the premises for what is authorized by the warrant, the manager or another representative should ensure that they do not exceed the scope of the warrant. Now, sometimes these situations are hectic. You can't tell. Agents can be very forceful. They are wearing guns, and they can be threatening. They can threaten someone with an obstruction if they do not comply with the orders of the agents. If you do not consent, you will make a note of that. Do not obstruct the agent if they insist on going through to a certain area, or they want you to open a vault or a safe, for example. It's not in the warrant to do it, but if you do it and you do not consent, we can object to the fruits of that search at a later time. There is also an administrative warrant. This is issued by an official at ICE. It's signed by an official at ICE, a supervising agent. Those types of warrants do not entitle ICE to enter private areas of the business. They authorize the arrest of an individual, a named individual, for the reason stated on the warrant. There could be an outstanding order of deportation for that, final order of deportation for the individual, and they want to take them into to custody pending removal. In any event, it doesn't authorize the agents to enter any portion of your facility. If it's in a public area, obviously they have the right to be there, but they don't have a right to go into the back of the house to search for an individual if all they have is an administrative warrant. While agents are there, you may try to take video of what they're doing by using your cell phone. They probably will object to that. Have paper and pencil ready so that you can make notes of what transpires during the execution of the warrant, all of which will be important to give your attorney after the warrant has been executed to determine whether or not there are legal grounds to contest the fruits of the search or the arrests that were made in executing the warrant. Can we go to the next slide? Some of this I'm already repeating. Maintain a thorough record. I'm assuming, Ed, that we will be giving participants today a copy of the slide deck so that this will trigger their memory as to what is important to do or not to do.
Yes,
Um,
Mary. The recording is a video recording, so everything that is on the screen they will be able to see.
all right. Um,
And actually, Mary, can I interject? There is a question. What someone would like you, there it's a two-part question to clarify the retention requirements for I-9s for former employees. That's the first part of the question. And then the second part, actually, why don't you answer that and then I'll tell you the second part.
all right. I am aware that in the restaurant industry, there is tremendous turnover. And you may have a lot of people who are there 3 days, they go and they never show up again. Well, unfortunately, they're subject to the 3-year rule. You have to retain the I-9 that you did for that person for a period of 3 years from the last day of employment. 3 years. And the other part of the question is, how long do you have to have an I-9 for current employees? You have to have an I-9 for current employees for the entire period of their employment plus 1 year.
Okay. And if you're not a mathematician like me, on the USCIS website, there's actually a calculator where you can put in the date that they started and the date that they left, and it will tell you how long you have to keep the I-9. So if you need an extra crutch, it's called, I think, an I-9 retention calculator. If you Google I-9 retention calculator, you can find that tool. Mary, the second half of the question is, if there is an audit, if you said that employers should not go to the ICE office to submit the I-9s, which I agree, they would like to, the questioner would like to know how should or how would they submit the I-9s in the event of an audit?
Okay. The notice of inspection and the subpoena will provide instructions on how to submit them electronically. If you maintain your I-9s in
Oh no, Mary's frozen again. We'll give her just and maybe let's give her about 60 seconds to see if she unfreezes, and if not, we can skip to the next section.
Okay, that makes sense.
Oh, there she goes. Hi, Mary.
I'm sorry. The way to do it is the instructions will be in the notice of inspection for the I-9 audit and the accompanying administrative subpoena. If you maintain your I-9s in hard copy form, you can do it electronically by scanning the documents and submitting the scanned versions to the service. The alternative is to deliver them by overnight mail or some kind of certified mail so that you have a record that they were actually transmitted. Always maintain a controlled copy of whatever documents you submit to ICE. They have a history of misplacing I-9s, and you could be held liable for missing I-9. Actually produce the document when you were supposed to. All right, on here, this is a humanitarian thing. If employees are arrested, I'm sure that you care about your personnel and you block or interfere with the agent's activities. You could wind up being arrested yourself, and that's the last thing you want to do, or being charged with obstruction. Don't give any statements to ICE agents. The liability of your employer or yourself without an attorney being present. The convenient thing to say is, look, I'd love to answer your questions, but my attorney has told me that I should not do that outside the presence of counsel. You may want to have, and I strongly suggest that you do have, your attorney's business card with you at all times, carried in your wallet, so that if you are caught in a situation of where you are being interrogated by ICE agents, or where they are serving some kind of notice or warrant upon you, that you are able to whip out that card and say, I have an attorney, and I would prefer that my attorney be notified that you are here. They may or may not let you do it, but you can always use that as a reminder that you should not answer their questions outside the presence of counsel. Don't direct employees to refuse to speak to agents when questioned. I know there are a lot of know your rights information pages going around, flyers going around, telling employees that they don't have to answer agents' questions. And that's fine if they acquire that information from those know your rights circulars. But the last thing you want to do is to say something like that in the presence of ICE, because it will be interpreted as an effort to obstruct their efforts at enforcement and may lead, in combination with other things that transpire on that day, it could lead to serious consequences, perhaps even criminal charges being brought against you. Do not hide employees or assist them in leaving the premises. Don't put them in the cold box. Don't put them in a cupboard. Don't tell them to hide. That's the last thing that you want to do, because that's an obstruction. It could also lead to a charge of harboring. And this is my last word. This Justice Department, this Attorney General, has advised the attorneys general in all of the states and her personnel in Main Justice to use all their efforts to cooperate with ICE in bringing criminal charges against employers for violations of the immigration laws. Principal laws that can get employers into trouble are harboring. If you have a business, you do not want to be engaged in either providing housing for personnel, transportation for personnel, paying them in cash or under the table, as they say, assisting them in obtaining documents to be used for I-9 purposes. These are all acts which could result in very serious criminal charges being brought against you, possible forfeiture of the business, meaning they take the business in its entirety, they take whatever facilities you're using to house people, they take whatever business premises are being used to employ them. So it's a cautionary note. Be an employer. And that means that's the extent of the relationship you have with your employees. You're not their landlord. You're not their transportation agent. You are their employer, and you comply with the law to the best of your ability in verifying their eligibility for employment and identity. And that's it.
All right.
Any other questions, Becki?
Yes, one other question for you before we turn to legal sponsorship options. So you discussed this, but just a clarification. So the person asked, if an officer presents a search warrant, you don't need to let them search. And so I don't think that's exactly what you said. So maybe you can clarify, if an officer presents a search warrant, what do you need to let them do and what don't you need to let them do?
All right. If they present you with a judicial search warrant, meaning it has been signed by either a U.S. magistrate judge or a district court judge, you need to let them do whatever the search authorizes them to do. It will specify a time, a date, and the scope of the search that can be conducted. If it says they can search the entire restaurant, that means the entire restaurant. If it says they can only search for computer records, then they search for computer records. Generally speaking, the U.S. attorney who prepares the search warrant is very specific about what they're seeking, and it will be a laundry list of things. It might be, in addition to persons who are undocumented, that's known as a Blackie's warrant. They don't necessarily have to name specific employees. any unauthorized individual. That may be a general warrant for undocumented individuals. Any computer records associated with that person, any computer hardware associated with those persons, human resource documents associated with those persons. Generally speaking, all of that is going to be spelled out in the warrant. A warrant is going to be issued in general when the U.S. attorney is also conducting some kind of grand jury investigation, looking into the crimes which are the sections of the code which are specified on the face of the warrant. Read the warrant carefully, comply with the warrant to the full extent. If it's overbroad, let a lawyer determine that. You're not a lawyer. Do not obstruct as they attempt to execute on the warrant.
All right. Thank you, Mary. So hopefully that was helpful. That was a lot of information, but I think that really that's something that we all need to be aware of these days, particularly in the restaurant industry.
Becki, let me interrupt for one quick second. Mary, thank you very much. Attendees, remember that you've got the questions tab. Mary's part is done, but if you have questions for her, go ahead and present them, and we will get them answered either now or later. So this is your opportunity to ask questions of people who know what they're talking about. So don't pass up on that. Thank you, Becki. Go ahead.
Thank you, Ed. So I'm going to touch briefly on legal sponsorship options. So my practice typically consists of helping employers to bring workers here to the United States legally and to keep them here legally. And we do have a focus in the hospitality industry. Our firm represents clients across the spectrum of industries, but the hospitality industry clients are definitely my true love as an immigration lawyer. So I'm just going to briefly mention a few options. And the first one is the J-1 visa. So this is sort of an entry-level visa. If any hospitality employer comes to me and they're interested in sponsoring somebody, this is the first visa that I look at. It has a pretty low bar to entry. So you need either 5 years of relevant experience, or you need a college degree and 1 year of relevant experience. The J-1 visa is 18 months in most industries. For hospitality, it's only 12. It's really sort of the quickest, easiest way to get someone here. And so it is a good opportunity for someone with not a lot of qualifications to come here and experience the U.S. hospitality industry. The next visa that we want to touch on is the Trade NAFTA, or TN. And we're talking about this particularly because this is a magazine for Latin restaurants. And so there are a few visas here that are sort of special visas. For certain countries, the TN is for Canada and Mexico. And in order to get a TN, you have to be in a specified occupation. So only certain occupations qualify for TN. The two that are probably relevant here are hotel manager or management consultant. If you have a restaurant that's in a hotel, that can sometimes fit into the hotel manager category. And if someone is doing management consulting, and it's important, this has to be actual management consulting, not like a restaurant manager that's called a management consultant. But we've had many cases where restaurants or restaurant groups do bring in a management expert to advise on the cookbook, menu development, whatever. That could potentially be the management consultant. It's a great visa. It's also pretty quick and easy to get if you are Mexican or Canadian and you fit into one of these categories. The next visa that we have is the H-1B1. And again, this is a special visa that applies to, in this case, Chileans. So we're going to talk in a minute about the H-1B, which is a professional worker visa. We sometimes can get those for restaurants for like a F&B manager, a restaurant manager, an operations manager, also for larger restaurant groups, like a finance director, an HR director. So professional degreed occupations for Chileans and also Singaporeans. there's a special sort of abbreviated H-1B, which is called the H-1B1. And that's all I'll say about that one. The next one is the H-1B, which is if you're not Singaporean or Chilean, this is the one that's available to you. So the occupations I mentioned are jobs that require a bachelor's degree in a specific field. The thing to know is if you are not from those special countries, the H-1B is subject to a cap or a quota. The cap has already happened for this year. So the earliest possible start date for a regular H-1B would be October 1st of 2026. So about 18 months from now. And you would have to participate in a lottery. So it's a tough option for someone who's not Chilean or Singaporean, but good to keep in mind if you do have a Chilean. The next option is the O1. We do quite a lot of these for people in hospitality. So you have to be distinguished in your field. It typically applies more to chefs or sommeliers. So think of really the litmus test that for O1s is the Google test. So if I can Google your chef and I'm going to see a lot of articles about your chef, that person is likely distinguished and would likely qualify for an O1. It's harder to do for front of the house staff because those folks tend not to receive as much publicity about their work. So not impossible, but I tend to think of this visa as being for chefs or sommeliers. And then I believe the last one is the E2. So this is a treaty investor visa. If someone wants to invest and create a restaurant in the US, this is a great visa for that person. And also, once the restaurant is set up, they can bring workers from that country. It has to match the nationality. So if you're a French restaurant, you can bring French people. If you're a Mexican restaurant, you can bring Mexican people, and so on and so forth. So let's talk now about options for people who are in the US, either in a humanitarian status or humanitarian situation, such as asylum applicant, TPS, DACA, and also individuals who don't have any status at all. And before, I'm going to put a pin in that because there is a question: how difficult is it for a restaurant owner to secure any of these visas? It's very fact specific. If you have a particular person that you're interested in potentially sponsoring, feel free to reach out to me. I'm happy to take a look at, quickly and see whether there could be possibilities for that person. But we do this all the time. I mean, there are all of the options that I just reviewed quickly are visas that we use all the time for legal staff in the restaurant industry. So it is definitely possible. And, really, that's how I built my personal immigration practice, is working with restaurants to bring staff here legally. So it's definitely possible. I don't want to lie to you and tell you it's, easy peasy, but many restaurants do it. So turning back to the population that is undocumented or here with a status like TPS, DACA, asylum applicant, repeating what I just said, every situation is fact specific. Our law firm does consult with folks about their options, but also we know that many people cannot afford a lawyer. We want to make sure that everyone who needs a lawyer is able to consult with one. There's a list of free and low-cost immigration lawyers. They're available on the Department of Justice's website, but we've also downloaded those lists to our website. So feel free to check out that list at the link here. So the options for these individuals can include employment sponsorship, although it's much more limited, and then family sponsorship and humanitarian options, which Kat is going to cover. So I'm going to tell you again briefly about the sort of conundrum with temporary working visas for people who are undocumented or in a humanitarian status. And the conundrum relates to what are called the 3 and 10-year bars. So basically, if you come to the US and you stay here more than 180 days, if you overstay or you're here illegally for more than 180 days, you can never legalize your status in the US. And if you leave to legalize your status, you have to wait outside the US for 3 years. If you overstay for a year or you're here without authorization for a year, you can't legalize your status in the US. And if you leave, you can't return for 10 years. This is why it's so frustrating to immigration lawyers when we hear members of the general public saying, all of those people should get a place in line. So there really isn't a line, and this is why. And having worked in this field for 30 plus years, if I could change any one thing about immigration law, it would be to get rid of these bars, because they prevent people who have employer sponsors, who have options. They prevent those people from being sponsored. So there are waivers from these bars, and the waiver that's most important here is called a 212D3 waiver. And essentially, this is a balancing test. So what are all the good things that you did, and what's the nature of your offense? So you overstayed by 181 days, and only because you were taking care of a sick relative, but you have contributed all sorts of time to charity, and you attend church, and you've done other excellent things. So they just weigh the positives and the negatives, and look at whether you can be issued a waiver. So if you're eligible for a waiver, then some of these options that I just discussed could become available for some of the individuals in this situation. So, and this slide basically says exactly that. So, so that's a very brief summary. I think most of the people that we're talking about, this is not going to be the first option for them, but I did want to let you guys know that there are legal options for sponsorship in the restaurant industry, including with a waiver for some people, especially DACA kids. We have done, a number of cases for DACA kids who have options for sponsorship and have received waivers. So definitely something to think about. So we're going to move on to humanitarian and family-based options. And I'm going to turn it over at this point to Kat to talk about the options for these individuals.
Thank you, Becki. And I'll try to be brief here to allow time for questions. But as Becki said, we're going to cover some of the main types of humanitarian relief. I will touch just very briefly on family sponsorship, just because it is one of the most common pathways to lawful status in the U.S. Just to point out that there are two different types of family members that qualify for family sponsorship by a U.S. citizen or lawful permanent resident. So there's immediate relatives of U.S. citizens, and those are going to be your spouses, unmarried children under 21, and parents of U.S. citizens. For these folks, there's an unlimited number of visas available. So these family members can become lawful permanent residents fairly quickly, sometimes within 1 to 2 years of filing the application. On the other hand, there's another category called the family-sponsored preference relatives, and these are the adult children and siblings of U.S. citizens and spouses of and unmarried children of unlawful permanent residents. And for these folks, there's a limited number of visas available, and the wait time can really vary significantly depending on the type of relationship, the country the person is from. For example, siblings tend to have a sometimes decades-long wait period. So it's not always a realistic option, but I wanted to point that out since it is such a common pathway to citizenship in the United States. As for our humanitarian options, we've listed a good amount here. This is not the entire list. There are additional forms of relief for people that are in deportation, but this will give you a good overview of the types of relief for people affirmatively. We'll touch on the first three, TPS, DACA, and asylum, a little bit more in the further slides. But I'll just note for crime victims, there's a special visa called a U visa, and that's available for people who've been the victims of certain crimes and have helped law enforcement investigate those crimes. And there's a similar visa available for the victims of human trafficking, and that can be labor trafficking or sex trafficking. And they need to have been people that have assisted law enforcement in investigating the trafficking incident, and that's called a T visa. And there's also a special immigrant juvenile status, which is primarily for children who have been abandoned, abused, or neglected by their caregivers. and VAWA. That's the Violence Against Women Act. And although it has the word women in the name, it applies equally to men and women who are the spouses, children of abusive relatives, and it allows them to adjust status to become lawful permanent residents without their abusive family's participation. So we can move on to the next slide. Great. So temporary protected status, TPS, as I mentioned, we're going to take a closer look at some of these forms of relief. These are ones that you might be hearing about a lot in the news. They're getting a lot of media attention these days, and there's a lot of ongoing litigation surrounding this status and the others that we'll touch on. So TPS is a temporary immigration status that's available for countries where the Secretary of Homeland Security has designated a need for protection. So this tends to be in cases where a country is going through severe civil strife, war, massive natural disasters, earthquakes, hurricanes, things that are really destabilizing a country. These are the circumstances that a secretary might consider worthy of designating the country for additional protection. It allows people to stay in the US without fear of deportation and to apply for work authorization, but as is implied by the name, it's temporary. It doesn't lead to any permanent status. So the person may be able to adjust through other avenues, as Becki was mentioning for DACA. Sometimes, likewise with TPS, there may be other avenues that become available to someone, but TPS in and of itself is not a pathway to citizenship. And we can go on to the next slide. DACA is another form of relief that you might have heard of. Over 500,000 people have been the beneficiaries of the DACA program. It was created in 2012 to give temporary protection to the children who were brought to the United States, often when they were very, very young. You may have heard the term dreamers. The folks that grew up in the US, they've set down roots here. Sometimes they don't even speak the language of the country that they're from because they came here when they were so little. And this program was designed to provide some relief for these folks. So it gives protection in 2-year renewable periods, and it allows recipients to apply for employment authorization. But like TPS, there's no pathway to permanent residency through DACA. And as we'll discuss in a moment, the program is under threat with litigation. Currently, no new applications are being accepted, only renewals. So we'll talk about that. But in the big picture, DACA has had a really huge impact, but not a permanent solution. So we'll talk more about kind of the current state of litigation with DACA and TPS right now. So TPS is available to people from over a dozen countries. You'll see some of the names listed there: Ukraine, Venezuela, countries that are in significantly difficult scenarios. And many TPS holders, they live here for many, many years, but their status is temporary, as we've mentioned, so it can be rescinded without really any warning whatsoever. And we're seeing that now with Venezuelan TPS. Earlier this year, DHS announced that it would end protection, or actually vacate protection under the 2023 designation of Venezuela for TPS. So for a moment, it looked like nearly over 250,000 Venezuelans were going to lose the ability to stay in the US. But at the end of March, a federal judge blocked the government from vacating that designation. So for now—
Can I have a footnote here?
Yeah.
I mean, they really can't do it arbitrarily overnight. They have to comply with the Administrative Procedures Act. And to the extent that the prior administration was able to document the existence of the conditions that justify the imposition, the authorization of temporary protected status under a statute passed by Congress in 1990, the new administration cannot, with a stroke of a pen, terminate it. They have to demonstrate that the evidence adduced by the prior administration was faulty or no longer applies. And that's why the courts have enjoined the current administration from terminating it peremptorily. Sorry.
No, that's very helpful. That's exactly correct. Suffice it to say, the future of TPS is uncertain, though it has been blocked right now. The vacatur has been blocked. An appeal is likely forthcoming, and we anticipate that this protection is unfortunately not the most reliable path forward right now. DACA recipients are likewise in limbo, and they really have been since the inception of the program, constantly embroiled in legal challenges. Since 2021, the program has, USCIS has been unable to accept and adjudicate new applications. And most recently, in January, the Fifth Circuit ruled against the Biden administration's attempts to codify the program. However, in good news for DACA recipients, the court did allow USCIS to continue to accept and process the renewal requests while the appeal is pending to the Supreme Court. So for now, those that have maintained DACA can continue to renew it. Anyone else that would have been eligible, unfortunately, at this moment cannot apply. So the big picture takeaway here is that these are both offer critical protections to people that have been here for many, many years, but these folks are living under constant threat of having their status revoked. And it's one of the biggest reasons we advocate for applying for permanent relief where available, speaking with a lawyer, and seeing if you might be eligible for something more permanent. We can move on to the next slide. Okay, so we've looked at temporary forms of relief, TPS, DACA, but we're going to talk about a more permanent way of staying in the United States, but one that is much more difficult, which is asylum. You're likely familiar with the term asylum and some of its features, such as the fact that a person needs to fear persecution in their home country on account of their race, religion, nationality, political opinion, or membership in a particular social group. And the harm needs to have occurred or will occur either by the government or by a group that the government can't or won't control. And there's two main ways that people get asylum. So there's an affirmative asylum process, which applies to people who aren't in removal proceedings and who applied affirmatively with USCIS within 1 year of entering, though there are some exceptions to the 1 year deadline. It's generally within 1 year of having entered the United States. And there's at least two major benefits to being in the affirmative asylum process. And that's that you get a non-adversarial interview with an asylum officer, which can make a very daunting process a little bit less scary when you're presenting your claim. And you also get two bites at the apple if you're denied. So if at the asylum phase, the officer finds that you do not meet the requirements for asylum, your case will be referred to the court. You'll be placed in removal proceedings, and you'll have a second chance to present your fear-based claims. So that brings us to the second type of of asylum proceedings, which are defensive asylum proceedings. And some folks end up there through USCIS by being referred, or other people are apprehended at the border or in the interior and end up in removal proceedings that way. In this case, when you're in the defensive posture, an immigration judge will decide your case. You'll have the opportunity to present testimony, to bring witnesses, to have evidence. But an attorney for the Department of Homeland Security will also have the opportunity to bring witnesses, evidence, and to cross-examine you. So it's certainly an adversarial proceeding and tends to be much more in-depth. Both the affirmative and the defensive processes have in common that they take a very long time. There's a very big backlog, both with USCIS and the Immigration Court, of asylum applications. So it's possible that you might be in this posture for a very long time. Fortunately, there is the ability to apply for a work permit as of 150 days of your asylum application pending. So most people are eligible throughout the years they may be awaiting their asylum adjudication to work legally in the United States. And I know we're almost at time, but I'll just say that there are some reasons that people might not qualify for asylum, like maybe they have entered the United States before and were removed. or they may have re-entered the United States with a removal order, for example. And there are other forms of relief for people in that posture that aren't eligible for asylum, but do have a genuine fear of returning. And these forms are withholding of removal and convention under the protection against torture, under the Convention Against Torture. These are much more limited, though, and they're much more difficult to get. They don't offer any pathway to citizenship. And what we're seeing in this administration that we haven't seen before is that people are at risk of being removed to a third country once they've obtained these statuses. So before, this used to be a pretty safe way to stay in the United States and work. You wouldn't be able to become a citizen or bring your family over to the US or travel, but you were pretty rest assured that you would stay in the United States. That's no longer the case at this time. So, but those are two other avenues of relief available. So I think that's all for me. Tried to go fast for you.
Thank you, Kat. So here we have our contact details, and as mentioned, our office handles all of these types of issues: employer compliance, legal immigration, as well as options for individuals with humanitarian status. And so we are available to help. And also, you will receive a copy of this presentation, which includes a link to free and low-cost immigration service providers for those who need to avail themselves or want to avail themselves of that resource. So thank you so much for attending this webinar. We hope that you have found the information useful, and thanks to El Restaurante for hosting the webinar. We hope everybody has a great afternoon.
Great. Thank you very much, Becki and Kat and Mary. Your information was so valuable. I know our attendees appreciated it, and many more will appreciate viewing the recording. So let me say thank you very much again for your time today. And attendees, thank you for watching. And be sure to look for the recording on the elrestaurante.com website. And with that, we'll end today's event. Thank you.
Thank you all.
So much. Bye-bye.
Thank you.
Bye now.